To answer another question that hasn't been asked, Michelle is devastated. Her daughter has been informed. Her daughter was not here. Her whole family is devastated. I heard some of what they said. I've been doing this a long time, and it's not like I'm cynical or hard-boiled about this, but I truly just don't see how the jury could have reached this verdict. We intend to first file post-trial motions. One of them is going to be for a judgment of acquittal notwithstanding the verdict, and there will be many, many issues we'll present even before sentencing. We will also be preparing for sentencing. There's a lot of support. Michelle has a lot of support, and people will be submitting letters, and we'll be preparing for a May 31st court date. So if people have questions, I'll answer a few, although I don't really feel like it.
Tom, I forget, did you say you will be appealing?
Well, the first step is to file post-trial motions for new trial, where I list any number of reasons why the trial itself was not fair. Some of the issues predate the actual trial, going back to the hearings that took place in the fall, some of the rulings that go back a couple of years. So it's going to be a post-trial motion that lists all of those things. Normally those are pro forma, meaning you file it just to file it. I believe that many of those issues have merit, and only if those are denied and Michelle is sentenced, you then file an appeal, and the question is, what do you argue on appeal? In my view, it's not just whether there are any issues, it's which ones not to argue because of how many errors I think there were in this process.
Is she going to bond out today?
It appears that the amount is too high for the bondsman to be able to post without getting additional surety approval. So it appears she will not be getting out today. We hope that she'll be getting out in the next few days, but it's not going to happen today. She is going to be going to York and Niantic.
Sir, what does a prison time look like for Ms. Troconis?
I don't want to even speculate. The maximum penalty has been set forth, but it's somebody with no criminal record. She is not accused of herself of harming anybody, but it's serious charges that she's been found guilty of. So it could be several years. Let me put it that way.
After the playback of testimony from the friend and then yesterday's question, what was your mindset as you arrived in court today?
Well, I thought that the question of when they wanted to hear back from Clara Duperon was favorable. The way, though, that they asked the question, did the jury feel that you actually had to physically touch any of the items in order to be guilty of tampering? I didn't particularly like that question, but as I think I said yesterday, because the definition of accessory was separated from the charges of accessory to commit an offense, I thought it could be neutral. So I don't speculate and go, oh, that's a good question, that's a bad question. You could sit there all night and think, well, why are they asking that question? It could be one person wanted to know. They just didn't know that the statute 53A-8 meant accessory. The only other thing that if I can, I have a wider audience here, is that people, in my view, should never sit down with the police for interrogation. They should never do it, because people forget it's not just things that are bad that can be used against you, it's anything can be used against you, and that's what I feel was done here.
Do you have any insight on the strategy that was in play at that time, in June of 2019?
I have no insight as to why any lawyer, without either an immunity agreement or a proffer agreement, would walk their client into a police interrogation without knowing very much about the offense. Now, that's me, so you might want to ask the lawyer that did that. At least we know one other lawyer that, for Mr. Gumieni, got an immunity agreement in order to have his client cooperate. that is the strategy that would have been the more appropriate, in my view, again, reasonable action for a lawyer to take. But you're going to have to ask that attorney why he did what he did. In my view, the entire case, and even as closing argument set forth, was based on what she said to the police during these hours and hours of interrogation. And I guess the jury did not accept the fact that people are not fluent in English, or who are tired or badgered, are told lies, and then asked to, now what do you think? Now are you willing to admit that you didn't act truthfully before? You know, you can draw negative adverse inferences from that. Just in my view, it shouldn't be enough to find someone guilty. But again, that's my view.
The family is adamant that this was not a fair trial. What do you think?
It is not for me to decide whether a trial is fair or not. I believe these jurors were fair based on the evidence that was allowed to come in and the way that things were instructed. My issue will be whether or not the rulings that allowed in certain evidence, that allowed in hearsay, in my view, were incorrect, and therefore there was a due process violation and errors that would entitle Michelle to a new trial. But, you know, I'm not going to get into questions of fairness and whatnot. That's not really my role.
In hindsight, should she have taken the stand?
You know, in hindsight, as I argued in my closing argument, hindsight can be 20/20, right? I don't know if it would have mattered. The jury got to hear an unbelievable number of hours of unfettered interrogation. She answered questions till they had no more questions. Some of those questions, in fact, were posed by her lawyer in those recorded interrogations. So whether or not she needed to say anything, what could she say that she had not said during those interrogations? They would have just asked her, well, you said this on this date and this on that date. She answered every one of their questions. My view, she shouldn't have said anything. But that's what I look for in hindsight. I did not represent Michelle at that point. But we'll go forward. We're going to challenge whether or not the trial had errors that should be reconsidered, and if not reconsidered in this court, then we'll go to the appellate or Supreme Court. Thank you.
Is the contempt hearing still on for Tuesday?
I'm not involved. You're going to have to talk to Attorney Frost, who represents Michelle in that case. That's all I know. I'm not going to be here on that.
Thanks, John.